everyone, welcome to LegalWiki. Today I'm having the pleasure to host two esteemed guests on our channel, Mr. Mridul Gupta and Rajat Prakash. Mr. Gupta is a practicing advocate at the chambers of Sujit Ghosh. He handles matters related to commercial litigation. On the other hand, Mr. Prakash is a legal advisor at Biryani by Kilo, focusing primarily on the FMCG sector. A very warm welcome to you guys. Thank you for accepting the invitation and taking out time from your busy schedule.
Thank you, Surbhi. Thank you.
Thank you for extending the invitation. Looking forward to the discussion.
So continuing with this, in today's session, we will be discussing the famous basic structure doctrine propounded by the Supreme Court in the Kesavananda Bharati case 1973. In a 7-6 verdict, 13-judge bench ruled that the basic structure of the Constitution is inviolable and could not be amended by the Parliament. It has been 15 years today and it has protected our Indian democracy. But recently, we can see a tug of war going on between the judiciary and our government. As a Vice President Jagdeep Dhankar and the Law Minister Kiran Rijiju criticized the Supreme Court using the Basic Structure Doctrine to struck down constitutional amendments made by the Parliament, such as the National Judicial Appointment Commission Act. To this, the Chief Justice of India, D.Y. Chandrachud, compared the basic structure of the Constitution to the North Star, an unfailing guide which shows the path when the road is unclear. With this, we are here to discuss the tussle going on between the government and the judiciary. So let's start with our conversation. So shall we, guys?
Yeah, sure.
Okay. The first very basic question for you guys are, what do you understand from the basic structure? Most of us, we actually don't understand what the basic structure is. And has the basic structure been defined anywhere?
Rajat, would you like to take the question first?
See, a basic structure has not been defined anywhere. Okay, but as you can say in a common man language, a basic structure is an indispensable element in our constitution. It's just an essence in our constitution, without which main essence of constitution would be nothing. So, like in agreements, in contractual फेज जब हम अग्रीमेंट्स बनाते हैं तो अग्रीमेंट्स में भी कुछ एक बेसिक क्लॉजेस होते हैं जो हम एक कॉन्ट्रैक्ट से उसको हटा नहीं सकते हैं. लाइक बॉयलरप्लेट क्लॉजेस आर दोज क्लॉजेस जो बेसिक मिसलेनियस क्लॉजेस हैं जो बेसिक होते ही होते हैं. वही सेम अप्लाइज इन द सिचुएशन ऑफ कॉन्स्टिट्यूशन ऑल्सो. कॉन्स्टिट्यूशन में भी कुछ बेसिक क्लॉजेस हैं जो सिर्फ बेसिक एलिमेंट्स हैं जिसको हम नहीं हटा सकते.
So correct. Mridul, would you like to add anything to this?
Yes. In order to grasp a better understanding on what basic structure is, so imagine a building. Like it has to have certain structure which is permanent in nature. If you strike that, the whole building will fall off. Right? So you may change the room, you may change the fittings and fixtures, you may decorate the room, you may do whatever you want to inside that particular structure. But if you attack that structure or try to bring changes to that structure, the whole building will fall off. So similarly, over the years, when the judiciary came into picture and when the cases were decided, like we are not going into details of the cases which brought forth this particular doctrine of basic structure. So while the judges were interpreting the constitution, they in their wisdom came up with something called basic structure and said that yes, our constitution stands on certain pillars and certain principles which are very basic in nature. The most striking of them is the fundamental rights, right? So you cannot alter the fundamental right. Now here one more thing I need to add. When I say alter, or when you hear alter in the general news, etc., alter does not mean bringing in for the change. It's a negative change that cannot happen. Like in the fundamental rights also, Article 21A has been added. So fundamental rights have been amended, but in a positive manner. So when I say amendment or change, it cannot be changed negatively. It has to have some sort of positive change only. So that is the understanding of basic structure. Now, if someone wants to ask me and holds me to a gunshot and says, this is a constitution, these are the provisions, and pinpoint me to where is the basic structure, I will say, I cannot point you to any specific article, specific schedule, etc. But yes, if you want to have some sort of guidance, you may start with the preamble. So preamble have certain things, certain words. If you say socialist, democratic, sovereign, so these are also the basic structures. Sovereignty is a basic structure, right? It has to have basic structure. Like, in order to be India, you have to have sovereignty, right?
Correct.
So yes, in order to find some sort of light as to where to start your journey from, you may refer to the preamble. And one more thing, basic structure has been developed on a pre-existing doctrine by the name implied limitations. So I would like to just explain very briefly what implied limitation
Continue.
is. So implied limitation is a limitation in a constitution document. It is not per se any statute. In a constitution document, which puts a certain restriction on the amending powers of a particular legislature to amend a constitutional document, right? So in Article 368, it says it gives power to the legislature to amend the constitution. But to what extent, right? If the legislature wants to repeal the constitution altogether, whether it can do so? No, it cannot. It has to have certain things which need to remain. You may change the constitution altogether, but there are certain things that need to remain. You cannot repeal the constitution under the garb of changing the constitution. So this particular doctrine has been expounded to come up with the basic structure. So this is the general understanding of basic structure.
So basically what I can understand is that there is no proper definition of basic structure. It is basically an essence which protect our Constitution of India, so that the damage does not happen and the parliament is not getting the unbridled power so that they can do any kind of a negative amendment. So positive amendment is allowed and the preamble is a base of it, right? So negative amendment
not the base
stop
of
the
it.
negative amendment.
Yes, I will not say it's the base of it. I will say you can take
It's
some
a part
hints
of it.
from
Okay.
there.
It's a part
Yes,
of it. Yeah.
Yes,
So that
yes.
the negative amendment does not happen and so that the positive amendment should happen, so that we are just putting a limitation to the doctrine which you have talked about, the theory of implied limitation, so that it does not happen that parliament is exercising their power to amend the whole constitution, right? So that we have created a base called basic structure. Okay, so moving on. So what does actually lead to the beginning of basic structure? What happened? So because when the constitution was made, there was no basic structure kind of a thing, right? So the basic structure was propounded in the case of Kesavananda Bharati case, right? In 1973. So what happened that it was propounded in the year 1973 actually?
Should I take this question?
Yeah, sure.
Okay. So in order to come up to Kesavananda Bharati, you will have to go through a series of cases, right? So in the series of cases, there were, so the first case, I'm not able to remember the name.
The Shankar Prasad case?
I think so. What happened? The Supreme Court of India held that when a legislature is exercising its constituent power, it may do so without any limitation.
Right.
It can amend the constitution to any extent possible. So it began there. So it's a whole journey from the constituent powers have no limit to Kesavananda Bharati. Yes, the constituent powers have some limit. So in this journey, what had happened? So the legislature, I will not name any specific political party here. So the legislature which was in power during that particular era was doing something to protect its power to the extent whereby it cannot be eliminated from the power or pushed away from the power. That is what was being seen by virtue of the various constitutional amendments that were being brought forth. the most striking of them are the land reforms or the agrarian reforms.
Correct.
Right. So also, in addition to in all this conversation, Schedule 9 becomes very important. So Schedule 9 gives legislature the power to make laws which the judiciary cannot review. If some law falls in Schedule 9, the judiciary cannot review it. So any constitution amendment was being populated into Schedule 9. Any law, Schedule 9. Any law, Schedule 9. Right?
So that the judiciary will not be having a power to review it.
Yes. So ultimately, when you read the constitution as a whole, one of the striking basic structure parts is separation of power and the checks and balances in all the three pillars: executive, judiciary, and the legislature. Now, if one particular pillar tries to get all the power, right, what it will do? It will shake the balance of the country as a whole. So in order to have a check and balance over what is the limitation of your power, that is the basic structure. It's fine. Ultimately, you have to save who? The citizens of India. Right? If the citizens are not there, who will you rule? Where is the sovereign? Right? Now, Rajat, if you want to add something.
Yeah. I briefly want to say that basic structure began from the time जब दोनों organs के बीच में, legislature और judiciary के बीच में जब clashes of opinion start हो गए regarding the validity of any law. Actually at that time basic structure का जन्म हुआ था तभी, when clashes of opinions happened between the two organs of the constitution of the democracy.
So basically the parliament started making laws and the judiciary starting reviewing it, and then the basic structure started.
The question was raised on the validity of that law.
Okay.
Oh, see, one thing basic structure does is, so we must have heard something, or we believe also that constitution is supreme, right? Supremacy of the constitution.
But now, contradicting this, many of us say that the parliament is sovereign. So there is again a clash. Ki parliament is sovereign or constitution is sovereign?
See, supreme.
Draft किसने किया था?
No, it's fine. You may say the parliament is supreme because it's the parliament who brought the constitution into being, right?
Yeah,
but don't you think the parliament is only getting a power from the constitution itself?
See, now here comes the tricky part. Where does the parliament derives its constituent powers? Right? Whether it is in Article 368, where do you locate the powers of the parliament to apply constituent powers, right? Where do you do so? Because even when the constitution was not in picture, the parliament applied its constituent powers to bring constitution into picture.
Correct.
So where do you locate? This constituent power? So one of the judges in Indian judiciary during 1950s or 60s said that it's a sui generis power. Sui generis means being in itself. If a sovereign has come into power, there is a parliament. By virtue of being a parliament, it has constituent powers. There is no need to locate it in a document. It has to have constituent powers. Right. So again, whether this sui generis power can be unfettered, can it give carte blanche to the parliament of the day? No, that should not be the case, because ultimately parliament is comprised of humans, and humans are susceptible to corruption. Corruption not in terms of monetary terms. Corruption may be in many terms, including the exercise of unfettered powers. I can crush you, etc. What I say is correct. I hold the supreme law. So these may be also a form of corruption. So.
Exactly.
Okay, so moving on. So recently you might have seen that everyone is criticizing the doctrine of basic structure, right? Especially the parliament. And why members of parliament want to pass a bill to overrule what has already been defined as a basic structure. Why they are thinking that basic structure is putting a limitation on their power?
Because उनको ऐसा फील हो रहा है ना, बिकॉज पार्लियामेंट इज बीइंग रेस्ट्रिक्टेड इन इंट्रोड्यूसिंग एनी लॉ जो उनके फेवर में हो, जो वो चाहते हैं उसको जुडिशियल रिव्यू से जुडिशरी रोक देती है. दैट्स व्हाई पार्लियामेंट इज बीइंग रेस्ट्रिक्टेड टू डू दैट.
So do you really think so? Yeah.
How will they overrule a thing which is not defined exactly? बेसिक स्ट्रक्चर डिफाइंड नहीं है. बेसिक स्ट्रक्चर कोई लॉ नहीं है जिसको वो रिपील कर सकते हैं. बेसिक स्ट्रक्चर इज नॉट अ स्टैट्यूट जिसको वो रिपील कर दें. जो डिफाइंड ही नहीं है उसको ओवररूल कैसे करेंगे?
But still basic structure is putting an impediment or obstruction on the constituent power of the parliament, right? Parliament जो है वो जो
Yeah.
laws बनाना चाह रही है वो नहीं बना पा रही है due to the basic structure.
Exactly.
Like we can see a preamble. Preamble में जो words है वो लोग बार बार private member bill पास करवाने की कोशिश कर रहे हैं. They want to actually remove the word secular from our preamble. But वो लोग नहीं कर पा रहे हैं. The reason being is basic structure. But why they want to do this? इससे उन्हें क्या
इसके
benefit
पीछे
क्या
भी-
मिलेगा? And is it like actually beneficial for our citizen?
See, if you analyze this properly, आपको ये पता चलेगा कि जो बेसिक स्ट्रक्चर जुडिशरी ने थ्योरी इंट्रोड्यूस करा है, ठीक है, उसको जुडिशरी का जो पावर है वो दिया किसने? पार्लियामेंट कॉन्स्टिट्यूशन से ही तो आ रहा है. लॉ डिक्लेयर्ड बाय सुप्रीम कोर्ट is must be followed by every citizen, is declared as a law by under the constitution. अब सुप्रीम पार्लियामेंट आज के डेट पे अपने ही सेट ऑफ वेब में फंस चुका है, क्योंकि वो वही कर रहे हैं जो सुप्रीम कोर्ट को पहले अलाउ करा. सुप्रीम कोर्ट ने किया, लॉ बनाया. अब सुप्रीम कोर्ट के उसी लॉ को ओवररूल करना चाह रही है पार्लियामेंट, जो कि वो नहीं कर पा रहे हैं. दैट्स व्हाई दे आर being restricted, and they feel that they are being restricted. They feel that they are being caught in their own web.
Okay, you can say that. Mridul, would you like to add anything to this? Ki why parliament? Yeah.
Yes. I'll try to find some answers in the constitution itself. So if you refer to Article 13 of the Constitution,
Yeah.
I'll just briefly read. It says laws inconsistent with or in derogation of the fundamental rights. It says all laws in force in the territory of India immediately after Constitution, blah blah blah, if such extension shall be void. So what does Article 13 says? Article 13 says any law which is in derogation to the fundamental right shall be void. It does not say it will be a bad law. It says that is not a law per se.
Correct.
Right. Now, what is the extent of Article 13? Right. Whether it should be read only when a particular statute is being passed, or it can go into constitutional law regime as well. Now, in order, we need to understand a distinction, normal distinction as lawyers. So there is constitutional law, then there is general law. It is under the garb of law, but when it comes to constitution, things move differently, right? So Article 13 says laws. So whether Article 13 may be restricted to only the statutes which the parliament is passing or the constitutional amendments as well. So first of all, Indian judiciary had to find answer to this. And during the course of proposition of basic structure, the Indian judiciary found what? Article 13 may be extended to the constitutional amendments as well. If any constitutional amendment is coming into force, if it is in derogation to the fundamental right, it may be void. It is void. Now, deletion of secular. So it's a very political term. It was included for political purposes only, I will say. But if you remove the word secular, for let's say it has been removed, but what about Article 25 then?
Okay. So we'll have to
Right.
amend that also, right? So
See, the thing is, you can profess your own religion, practice your own religion. If I delete, let's say if I delete secular from the preamble, it's fine. Let me do so. But what is the fear here? Why the judiciary is not allowing so? Because it is seeing one of the negative steps that may come into picture. That is, after deletion of the word secular, there may be, I'm not saying it will happen it will happen certainly. There may be a situation whereby your practice of religion of your choosing may be in danger, right? So one step leads to another. If you are a visionary, if you can see what is happening and what the intent of the people who are exercising power, you can very well make what may be happening. You can see what is going on and what is the next step. That is why. So if you want to have some sort of clarity, you may look at it from this angle that yes, the first step, you may say it's fine, but what is the next step? So a certain thing you need to stop at the hilt itself. It need not to complete its course.
So can I say that this is something like politics which is going on, that the parliament want to remove the term secular and the judiciary is trying to protect? Is this something politics connection or something? Because of this, they want the supreme power, they want to remove the basic structure, something which has been involved in a basic structure, they want to remove.
If you want to go ahead.
I don't think so. We cannot know the backstage story. There might be some politics going on, but we cannot comment on that.
Yes, see, politics is an integral part of any country. Like Montesquieu, the most famous person who talked about the separation of power. In its conclusion, it says it is impossible to draw a straight-jacket formula as to this is the functions of the executive, this is the function of the judiciary, this is the legislation, and they cannot interfere. At certain point of time during his research, he realized that there may be a situation whereby lines are blurred. There may be a situation where legislature is exercising certain judicial powers, judiciary may be exercising certain legislative powers, not to the whole extent, not to derail what is going on, but it is impossible to draw a straight line between the division. So politics is like intermingled. You cannot remove politics from the judiciary or the functioning of a country. There may be political motivations. Political motivation may be positive, may be negative. It's very difficult to find.
You don't know that.
Yeah.
Yes, it may be so. But the thing is, the presumption is, when such exponential things are happening, the presumption is that things may go wrong. Because that is what happens in the world. Everything is going wrong. You are doing firefighting every day. Like in your household as well. Every day you wake up, you see something is going wrong somewhere. Right? It's firefighting. That is how. If you want to bring about changes in something which has been going on, you want to change the status quo, chances are that it will go wrong in the first instance. That is what people are trying to protect. That is why this tussle that you are seeing.
Correct. So should we allow the basic structure to be judicially reviewed? So recently also Madan Lokal quoted that if basic structure goes, our fundamental rights too will go. Right. So should we allow judicial review for our basic structure, or will it actually our fundamental right will go if the judiciary will actually just remove the basic structure? What do you think?
See, yes, that will, but that's one point of view. ये जरूरी नहीं है कि basic structure चला ही जाएगा तो fundamental right will also be gone. That's one point of view. ऐसा जरूरी नहीं है. But we can sort this out by amicable negotiation between both the organs. जब judicial review भी जरूरी है और parliament जो legislature law बनाती है वो भी जरूरी है. But we have to work together. जो parliament है और judiciary दोनों को एक amicable negotiation करना चाहिए judicial review के time पर, so that we can find out कि उनका क्या intent है और हमारा क्या intent है. Like in the corporate sector also, when we used to do contract negotiation thing, तो तब भी हम other party का भी सुनते हैं और अपना भी बताते हैं कि what our intent behind this agreement and what your intent. Consensus ad idem होना बहुत जरूरी है. We have to be agreeable on the same thing in the same sense. Parliament में जो लोग बैठे हैं, they are grounded to people in the country. They know the requirements of the country, but judiciary नहीं जानती है. So we have to take both the stands. We have to take the requirements of people और हमें legal mind दोनों साथ में चाहिए. वी कैन नॉट एवरी टाइम क्लैश नहीं कर सकते, हम एक दूसरे पे अटैक नहीं कर सकते।
ठीक है, सो बेसिकली यू आर सेइंग कि वी शुड गो फॉर द जुडिशियल रिव्यू, बट एट द सेम टाइम दोनों को एक एमिकेबल सोल्यूशन पे आना पड़ेगा, दोनों को डिस्कस करना पड़ेगा बैठकर। ओके, मृदुल?
I will say that I do not have such clarity as that of Rajat. See, I'll just bring forth some ideas to play with. Now, what Rajat is doing from its discourse, he is putting forth the ultimate aim of a democracy. Everything has to be in a democratic manner. Public has the last say. Public is supreme, right? And these people who are in parliament are the elected representative of the people, and the people should have say in anything that is going on. That is the ultimate example of a democracy. Like everything that is happening, the democracy has a say in it. That is what it is.
For the people, by the people, and to the people.
It's fine. So that is the general understanding of what Rajat was saying, that it's the democracy which is supreme, and everything else comes as a secondary. If the democracy wants, it can do whatever it has. Now, I'll just briefly put forth a controversial philosopher into picture for this particular topic.
Sure.
So his name is Socrates. So Socrates is amongst a few philosophers who were against the idea of democracy. He said, I'll just paraphrase. So what he said was, bringing into existence democracy, pure democracy, is not possible. Why? Because people are not born equal. Not equal in terms of right what they can exercise. They have different qualities. They have different starts in their life. Some have a privileged start, some do not have such a privileged start. So their understanding of the world, their worldview is very different from one another. If you say that there is a democracy and a leader is elected democratically, I'll give you an example here. I am 10 people. We are part of a certain organization. What we do is we indulge into some research which will put all the humans on Venus. Okay, we want to populate Venus now. We are 10 people. We are doing the hardcore intellectual work. Now there are 15 other people in a different group who want to do what? They want to be hunter-gatherers. They're like, no, I just want to be hunter-gatherers. I don't want to indulge in technology, etc. Now here comes the part of democracy. I said you elect a leader from these 27 odd people to rule what is going on. So by virtue of a population which is higher than this, its worldview is different, this worldview difference, by virtue of simple majority, it won the leader making all the choices for every one of them, including who want to go to Venus. Right? Whether it is right or wrong, I do not know. But it is certainly wrong for the people who are suffering the brunt just because they did not have the number. So democracy has its shortcomings, but I will not say that I have this amount of clarity that Rajat has, but these are some ideas that you can play around with. Yes. So if democracy comes into picture, whether the population has assessed the leader in the best possible manner, or it is just the sheer number that have led to election of that particular leader. So these are some of the questions that you need to think about and come to your own conclusions. See, the idea of discussion is not to implant something in your brain.
Correct.
It's just to give you thinking points that this is also an idea and why a particular decision or understanding may have taken place at that point of time, especially when it comes to judiciary. So yes, I will not say that it is up for debate whether the basic structure doctrine should be reviewed altogether, but it is not yielding any negative results as of now. That is what my understanding is.
But it might be. We are not sure, but it might.
Very well. Like corruption can happen in legislature, corruption might very well happen in the judiciary as well. We are all people. We are susceptible to corruption. That is fine. But as of now, if we look at the status quo, the basic structure haven't done any harm per se to the
correct,
people in general.
absolutely correct. So per se
So
it has not done any
why
harm,
there is
but-
why there is a need to tinker with it? That's my position here.
So now imagine a situation. What if there was no basic structure? What would have been the current scenario? So basically, it is widely said that if there would not have been a basic structure, Parliament with the supreme power would have amended our whole constitution, including the essence of the constitution, and it would have suffered the loss of identity. So what do you think, if there was no basic structure, what would have actually the present situation of our country?
See, yes, I agree. अगर कॉन्स्टिट्यूशन में बेसिक स्ट्रक्चर नहीं होता तो बहुत ज्यादा क्योस हो सकता था आज के डेट पे कंट्री में. ठीक है, अ फ्री हैंड अगर आप देते हो पार्लियामेंट को, अ फ्री हैंड गिवन टू द पार्लियामेंट दैट would have destroyed the sanctity of our constitution today at this date. India would be in a huge chaos right now. जैसे as for an agreement भी, किसी कॉन्ट्रैक्ट में भी अगर आप बेसिक क्लॉजेस हटा देते हैं, अग्रीमेंट विल परफॉर्म. ऐसा नहीं है अग्रीमेंट इनवैलिड है, अग्रीमेंट परफॉर्म होता है. पार्टीज अपने अपने प्रोमिसेस परफॉर्म करते हैं, पार्टीज अपने अपने ऑब्लिगेशन और ड्यूटीज परफॉर्म करते हैं, बट at some point of time वो एक chaos, वो एक dispute arise कर देगा in future, जो दोनों parties mutually decide नहीं कर सकते, जो दोनों parties mutually solution पे नहीं आ पाएंगे. That will create a chaos at the end of the day.
So it would have been the negative impact, right? So
Exactly.
country हमारा
ऐसा
फिर
नहीं
भी
है कि
function
basic-
करता, हाँ country हमारा फिर भी
करता-
function करता, but it would have been the negative impact to it.
Exactly. पार्लियामेंट सारे लॉज कुछ भी लॉज बनाते और that will have violated the fundamental rights of an individual in our country.
Mridul?
I'm just thinking on the terms, like, can I find a jurisprudential answer to it?
Yeah, obviously. Most welcome.
So, yes. So, imagining a situation whereby the basic structure is not there and the parliament has a free hand, I'll have to go back to the Hart and Fuller debates. So I'll just briefly give the backgrounds of Hart and Fuller debates. So these debates are not the usual debate that you see in the debate shows.
Mm-hmm.
So what had happened during that era, HLA Hart and Lon Fuller, these were the two jurists. And Hart was of the view that he wrote a paper in a journal whereby he said a law is a law. It doesn't matter whether it has morality, whether you think it is right or not. A law is a law, you need to follow it. So responding to this particular proposition, Lon Fuller said there has to be a certain inherent morality in the law. To have what? Internal consistency in the law which is ruling the subjects. It has to have certain inherent morality into it. Where does this debate find its place? So it finds its place whereby HLA Hart was analyzing a law in the Nazi era, whereby it was mandatory for anyone, if two people are there, if one person is criticizing the government, the other person is in the obligation to report it. If he or she does not do so, the person who did not report will go to jail and may be executed. So this was one of the laws. So law is law. That is what HLA Hart said. It doesn't matter whether we see the morality in the law or not. Fuller was of the different view. Now, relating it to the basic structure. What basic structure did, my understanding may be completely false. I'm okay with that. But this is how I'm trying to interpret it. It brought certain morality to the constitutional document. It says this is the inherent morality. This is something which you cannot challenge. You cannot go beyond this. If there is a situation, basic structure is not there, there may be a law. If I am a parliamentarian, I have the simple majority in the parliament, and I say, I am making a law that from tomorrow, everyone in the country will walk only on the left leg.
Okay.
And if the right leg comes down, that right leg will be chopped off. Assuming the people have both the legs, not showing any shades to differently able people. Right? So this is the law. What I say is the law. I have made it. It doesn't matter it has morality or not. Right? It what it is. It ought to have been that yes, people have the right to walk freely. They may walk in any manner possible. This is the ought law. Now we are going back to is and ought distinction propounded by David Hume. Now the law ought to have been that you are free to stroll around anywhere in the country. You are free to do so, except certain exception to the military areas or forest reserve areas. Right? But what I'm saying is yes, you first of all I'm putting a restriction on you where to walk, where to walk. Now I'm saying how to walk. But this is the law. You have to follow it.
Correct.
So in order to save something, like in order to have some sort of consistency, some sort of continuation, that it's fine whether it is perfect or imperfect. At the time of the country coming into existence, framing the first document of the country, that the whole soul of the country is this document. It has to have certain basic things to it. It has to give identity to the country which it has brought into existence. If there is no consistency, there is no continuity, then what is country? What is the country?
Correct.
Like today, India is a democracy. I amend the constitution. India is monarchy from tomorrow, and I declare myself the king. That might be the situation.
Correct.
Right? If somebody has been given unfettered powers throughout history, he or she has exercised it in a derogatory manner to the other person since time immemorial. You might pick up any religion. It has happened and it will happen. So this is one of the founding stones that basic structure brings in. That's what the judges say, that is what the view of the judiciary is. Because judiciary has also been given the power to maintain the constitution, to interpret the constitution and maintain its supremacy.
Okay.
Because at the end of the day, I may also add that parliamentarians are also the citizens of the country first, then parliamentarians later.
So basically what I would have understood, it would have been the Hitler situation where the parliament would have taken the right of all the people and we would have been the slave to them. जैसे law is law, जैसे parliament ने जो बना दिया वही हमें follow करना है. We cannot go beyond that. जो development है वो रुक चुका होता. जो हमारे rights है वो चले गए होते.
I'll just interrupt you and say. Previously when I was I'll bring you back to the idea which I discussed earlier, that democracy, all people are not able to assess their leader. There may be a situation where a lunatic becomes the leader of a democracy. If a lunatic becomes a leader of the democracy and he or she has unfettered powers, now you can see where it is going ultimately.
Correct.
Continue.
Okay.
Sorry.
So basically I have answered my next question also, that as you said कि basic structure अगर नहीं होता तो basically it would have damaged the development of our Indian jurisprudence and there would have been stop and we would have been the slave to the Indian parliament because we don't know. Like if you have given the example of कि if they would have chopped our leg, तो obviously बस आपको ऐसे ही चलना है, जो law बना दिया वही follow करना है. So basically the basic structure actually given the development to our Indian jurisprudence and a right to our Indian society citizen, right? So with this moving on, so you might have seen that there is a war going on between the executive and judiciary. Executive wants a representative in the collegium system and the judiciary wants a lawmaking power because of the voice vote which is going on recently. क्योंकि ultimately क्या हो रहा है कि जो भी laws parliament बना रहे हैं वो किसके पास आ रहा है? Judiciary के पास. And now there is a lot of burden on the judiciary. So now because of this there is a clash going on between them. So now अगर हम लोग ये चीज कर देते हैं, so obviously this will be a violation of separation of power, right? Because we have to maintain this, क्योंकि एक दूसरे के power में कोई indulge नहीं कर सकता. And the separation of power is ultimately the basic structure. So what do you think? कि we should give a representative to the parliament in the collegium system? Or should we give judiciary a law-making power? What do you think would be the right thing to do?
See, firstly, separation of power is a basic structure concept, but हर चीज straight jacket formula में नहीं होता है. Everything is not perfect in a democracy and everything don't falls in a straight jacket. But as if we see कि जुडिशरी में अपॉइंटमेंट कैसे होना चाहिए, अगर ये क्वेश्चन है और पार्लियामेंट्रियंस ये चाहते हैं कि there should be one people from the parliament in the system of appointing a judiciary, of appointing a judge in Supreme Court. Okay, so if we compare this to the corporate world, whenever one person is being interviewed by any company, ठीक है, तो उसमें बहुत सारे मेंबर होते हैं जो अपॉइंटमेंट के प्रोसेस में होते हैं. कंपनी का सीईओ भी होता है, उस डिपार्टमेंट का एचओडी होता है. देन आप उस सिनेरियो में देखो कि उस सिनेरियो में फाइनल डिसीजन मेकर कौन होता है, दैट अ पर्सन इज फिट फॉर द डिपार्टमेंट और नॉट, कौन करता है. इफ वी कंसीडर द लीगल डिपार्टमेंट ऑफ ए कंपनी, तो लीगल डिपार्टमेंट में कोई लीगल मेंबर फिट है कि नहीं, ये कौन डिसाइड कर रहा है फाइनली? द हेड ऑफ द डिपार्टमेंट. CEO also interviewed that person, HR department also interviewed that person, but final decision maker is the head of the department, because he knew कि what he wants, what kind of personality, what kind of mentality of a person he wants in his department. He knew it very well. ठीक है, तो अगर हम एज ए सजेशन हम इस चीज पे, इस पॉइंट ऑफ डिस्कशन पे हम बात करते हैं, तो एज ए सजेशन हम ये कह सकते हैं कि इट्स ओके अगर पार्लियामेंटेरियंस चाहते हैं कि उनका कोई एक मेंबर हो सिस्टम में, इट्स ओके, बट द फाइनल डिसीजन मेकर शुड बी सीजेआई ओनली. द चीफ जस्टिस ऑफ इंडिया शुड बी द फाइनल डिसीजन मेकर. इफ ही सेज कि नहीं, ये पर्सन फिट नहीं है, कंपैटिबल नहीं है एज अ जज इन द सुप्रीम कोर्ट, देन ही shouldn't be appointed. So at the end, decision maker should be judiciary only. The person may be nominated by the legislature, person may be nominated by the executive of the country, but the final decision for the appointment of a judge should be in the hands of judiciary only.
So basically, as per you, there should not be any representation of parliament in the judiciary. And you have so correctly related with the corporate culture. Okay, so moving on, Mridul.
Again, like, what happens is I keep going back to the basic human tendencies in every situation. Like, when we prepare for something in which maybe in future we think that future something negative will happen in future, and we prepare for that.
Correct.
Like, I'll give you very, very simple example. You save money for what?
For the future
Because
only. Yeah, there might be some inevitable thing comes.
There may be a situation where you are out of job.
Correct.
Like in our profession, we find ourselves very frequently that we are out of job for some time, because the cases may come in, may not come in.
Yeah.
It's a cycle.
Correct.
So we save money for a negative situation. So when we are making any laws, right? So we are again thinking of a negative situation. And what is the role of a elected government? I'll just again ponder on that. So the role of an elected government is one of the essential function is to ensure the interest of the person who has least amount of resources, like who are starting their life at the fag end of the race, if I may call it. So there are people who are like 100 meters ahead, 2 kilometers ahead, but people who are starting their life at the very end, very tail end of a structure. So if anything, if this particular parliament does not have a say, it may come up with a proposition that in judiciary what they are doing is they are indulging in elitism. They have qualified themselves as persons who are elite, and they are only competent to appoint the judges, like who should continue the judicial process. I was saying, so the parliament may come up with a proposition that yes, I do not have a say, and judiciary has qualified themselves to be the elites and they have the sole understanding that this is the judge who is qualified to rule the roast. They may very well say so. And this is what they are saying when they criticize the basic structure doctrine. The whole issue is that they do not have a say in judiciary. But again, going back to my initial thought that negative things will happen, and we need to prepare for that. Let's say if a democracy, the people in the parliament have a say in the appointment, right? If there may be a situation, and continuing with Rajat's point, that the CGI ultimately has the final say. So they may be saying that this person should be appointed, and each time CGI keeps on rejecting it. Ultimately, what will happen? The parliament will say that, again, though we have a say in it, ultimately we do not have a say in it.
Ultimately, the CGI is only having
and the sentiment of the people will go against the judiciary.
Correct.
And this is where we are entering the chaos. Once the people lose confidence in the judiciary, it's a complete havoc. What is going on? Who will you go to? What is justice now? When you don't have the confidence in the institution which has been entrusted with the responsibility of doing justice, and you don't have confidence in it, what will you do? At the end of the day, you will have to choose violence. We are going back to the era of guns. Ultimately, you what will you do if you are constantly being attacked, and not attacked physically? You feel threatened. What will you do? Like there are, not throwing any shades to people, but there are people who live in their basement and constantly thinking about that life is very difficult, right? Life has been arbitrary, life has been unfortunate, etc. So what they will do, they come up with guns and shoot people out of a sudden, right? So these things happen. So ultimately, if you feel threatened all the time and you see that I don't have any recourse whatsoever, I don't have an institution who can dispense justice to me, but ultimately you will choose violence. Ultimately, I'm saying. So, because rationality goes out of the picture once you see that injustice is taking place, your rationality goes out of the window. You can feel your rationality going out of the window when you're standing in a line in the State Bank of India. Right? It's a first come, first serve basis, but the line is not moving.
See, but my point is,
temper.
But my point is, how then we will bring the transparency? How will understand ki the judiciary, the working, the appointment they are doing is like it's transparent, it's in a perfect, because it's very difficult to build a trust, right? Because we have seen a lot of things being going on in the judiciary also. Because of that, people are ultimately losing their trust on judiciary. So how we can develop that transparency so that we can start believing on, so whosoever the judiciary is electing is the perfect for us, we the people of India.
Rajat, you want to go ahead first?
See, ऐसा कोई वो नहीं है, स्ट्रेट जैकेट वो नहीं है, कोई प्रोसीजर तो है. इनफैक्ट अभी भी कॉलेजियन सिस्टम में जैसे अपॉइंटमेंट होती है फ्रॉम द हाई कोर्ट टू सुप्रीम कोर्ट, द जजेस आर बीइंग प्रमोटेड, दे आर वो एक क्राइटेरिया पे होती है, वो जो सुप्रीम कोर्ट के जजेस डिसाइड करते हैं और वोट्स के थ्रू होती है. एज सच इन फ्यूचर अगर पार्लियामेंट का कोई इंटरफेरेंस आता है तो फिर कोई ऐसा प्रोसीजर अडॉप्ट हो सकता है. देयर माइट बी सम प्रोसीजर जो पार्लियामेंट प्रपोज करे कि these eligibility, these are the eligibility criteria for appointing a judge in Supreme Court. So we actually
need to make some reform to make the system transparency and accountability.
Yeah.
Okay. Mridul?
Again, I'm just thinking out loud. See, when a judge is appointed to a high court or to a Supreme Court, his or her body of work is available in the public domain in the nature of judgment he or she has passed.
Correct.
So you can take, if see, what you are saying is simplistic view of putting in transparency that this is the criteria we have selected. But if you really want to investigate the person who is getting appointed, what you can do is just look at some of the cases he or she has decided. You will get a sense of whether the person is fair enough or not, because nobody has a impeccable record. There may be a situation where you will deeply disagree with the line of judgment that the person has given. It's
So
fine.
there-
These things might be considered. ये मुझे लगता है ये शायद अभी भी कंसिडर करते होंगे in case of appointing a judge.
In general,
So
I'm saying for the general public also. For the general public also.
So, but the
See,
point is, general public does not understand this thing, ना? क्योंकि वो लोग नहीं बैठ रहे. We read the judgments and orders, but the public don't read.
I understand.
the higher judges must they read the judgments of the lower judges जिनको वो appoint कर
But
रहे हैं.
what people need is the impact of their judgments on their lives. तब जाके उनको समझ में आएगा the judges we are actually appointing is actually a good judges. It's not some like अंदर ही अंदर कुछ political connection चल रहा है या फिर there is something nepotism going on.
You cannot see, there are judges who become judges basis the process that you just highlighted. There is no, I cannot pinpoint it or I cannot prove it, but everybody knows a judge who has become a judge by virtue of the process that you just highlighted, right? So you cannot say a system or an institution is perfect, but ultimately what is a net result? Net result is, for the current judicial system in India, it is keeping a check on the unfettered power of the parliament, and it has helped the democracy to grow in a positive manner. That is what my assessment is. Given I'm not very old, I'm fairly very young, I do not have experience of life, but this is what I have felt through the journey of life that I have gone through. So judiciary may be as imperfect as it is, but if we see the net impact, it is positive, not just slightly positive, very, very positive.
So I'm coming to my last question. So finally, what will be your suggestion to impasse this, to end the impasse? Because the tug of war which is going between executive and again the judiciary is again making directly or indirectly impact on us, we the people of India, right? So what would be your suggestion, what they should do to end this impasse? What do you think?
See, from my understanding, legislature and judiciary need to work together, need to sit together, because they need to understand they are working for the growth of our country. जैसे corporate में बहुत सारे departments होते हैं जो साथ में मिलके काम करते हैं for the growth of the company. उनको एंड अपने माइंड में ये इंटेंट रखना है कि whatever they are doing, whatever their roles are in the company or in the country, that is just because of for the growth of the country. At the end, country को benefit होना चाहिए. If अगर आप दोनों साथ में काम नहीं करेंगे, आपस में क्लैश करते रहेंगे, कमेंट करते रहेंगे, तो फिर कंट्री ग्रोथ कैसे होगा? So for the sake of the country, both the organs of the democracy need to sit together, need to negotiate with each other, need to understand the intent of both the bodies. तब जाके country का growth होगा. They are working for the growth of the country, not for the sake of the judiciary and not for the individual body.
Correct. Mridul?
ये भी समझना बहुत important है कि they are not undermining each other. They both are the supreme body. और कोई ना ज्यादा है ना कोई कम है. Balance should be maintained. A reasonable balance should be maintained in the working of both the bodies.
A proper balance and a proper negotiation might help.
Exactly. They need to think about it.
So for me,
Yes.
I still find myself going back to Socrates when it comes to such situations. See, ultimate solution propounded by Socrates was dialogue. Dialogue with whom and from whom. See, Rajat's suggestion is that the dialogue should be between the judiciary and the legislature. But I'll go one step beyond. I will say that dialogue must be internal first. To first ask, each organ must ask itself The people who are presently in the organ must ask themselves that's to what they want to achieve with their thing, right? If a particular organ wants to get
ये तो
rid of the
50 साल से
basic
कर रहे हैं.
see again, it's fine, it may take 50 years, it may take 100 years, it may take 150 years, but if
We are
you
doing
have,
this for 75 years.
it's fine, it may take another 150 years, it's fine with that. Like, see, America got its freedom back in 1774, right? But
Right.
they're still trying to identify, still trying to better themselves, right? They're still trying to better themselves. So similarly with India, if an organ feels that the other organs, this particular thing is putting forth an impediment in the development, then the dialogue should continue. See, that is the whole thing, dialogue. So dialogue, it's not between the judiciary and the executive per se. The individual who is putting forth the idea and bringing it through the organ, through the whole organ together, he or she must first clear its soul, her soul or his soul, that what he or she is trying to achieve. So dialogue should be internal first, then it should be brought forth to the general public, and it's fine, the dialogue should continue, may continue, because the people keep on changing, their ideas keep on changing, their understanding keep on changing. So dialogue may be eternal, but the dialogue should be there shouldn't be an impasse. That's the whole understanding.
Let's see how does it go. I hope they will able to find a solution. So here we have come to the end of our discussion. Thank you so much, guys, for coming to our channel. I hope this conversation would be helpful to all the young lawyers and others who would be watching. Thank you so much.
I also learned a lot from
Thank
this conversation. Thank you so much for inviting. Thank you.
Thank you for having us on this channel.